nuisance ordinance. This is not on the agenda for a vote, but I think the idea was that we probably wanted to have some discussion of it at this meeting, given the fact that we don't have the public here, and as a way to get the public some knowledge of what we're going to be looking at in advance. The purpose of this, I guess, is to deal with issues that arise in a police enforcement arena, to provide an additional tool to try and deal with properties that have just repeated occurrences. And this is not, I think first we have to understand, the first thing to understand is this is not about neighbors whose grass gets too tall, who have parties and noise late at night. This is to deal with serious issues. Those things all have code violations or noise ordinances or barking dog ordinances. Those can be dealt with in another arena. But this is to deal with what we call chronic nuisance properties. Now, those would be defined as this. It would be a property that within a 120-day period has 3 or more nuisance activities, or that within 365 days has 6 or more nuisance activities. And what we're defining as nuisance activities, and there's a whole list, but they're going to be serious things like drug offenses, gambling offenses, prostitution offenses, human trafficking, assault type offenses, distribution of obscene material, production of illegal sexual matter, those kind of serious issues that can occur and do occur even now on an ongoing basis in certain properties. And the procedure, and I researched a number of cities who've adopted these types of ordinances, and there are a number of approaches. Some of them are more punishment oriented. They deal with criminal prosecutions and fines and that sort of thing. And what we've tried to do is come up with what would be more of a solution-oriented process, so that under this statute, the chief of police would have the authority to determine when he thinks that there is a chronic nuisance property. And if the chief sees a property that met this definition, he would then send a notice to the property owner informing them that he believes it's become a chronic nuisance property, what the activities were that meet that definition, and telling them that they've got 7 days to contact him to try and work out a solution to that problem. Now, the property owner then, if he contacts the chief within 7 days, they would have a meeting and try and mutually come up with a solution to whatever the particular problem is. And then they would work towards actually entering into a contract for the abatement of the nuisance. And it could be as simple as eviction, or it could be, more creative in terms of what it takes to deal with the property. If they then reach an agreement, they would actually sign a contract, and the property owner would then have the opportunity to perform whatever the agreement has been, and if he does so, the nuisance is abated, that's the end of it. There's no fine, there's no penalty, nothing happens. If the property owner never responds to the chief, doesn't do what's been agreed to, or otherwise doesn't perform his duties under the ordinance, it would then be referred by the chief to me as city attorney, who would have the ability to file a civil action, not a criminal action, civil action in the circuit court, in which we could seek substantial fines of up to $500 a day for the period the nuisance is unabated, and other relief like an injunction from the court that would stop proceedings if necessary, that sort of thing. This proposal that we came up with, I've worked with Chief Kelly on this. He's had input into it. I think I can say that he supports it and believes it would be an effective tool for him in dealing with some of these ongoing problems. This is not something that you expect to be used on an everyday basis, but just as in the name of the ordinance, this is for really bad places where really bad activities have been going on, and you have property owners who apparently don't care about it. Now, I know people are sensitive to landlords who may legitimately not know what's happening in properties, may legitimately want to have good properties. In any civil action that was filed under this, it would be a defense for the landlord to establish that at all material times he could not, in the exercise of reasonable care or diligence, determine that the property had become a chronic nuisance property, and could not, in spite of the exercise of reasonable care and diligence, control the conduct leading to the determination that the property is a chronic nuisance property. So, you know, that exists. In good faith, if you didn't know anything about this and you're getting in there trying to correct the situation, you've got a defense to any action that's made. This is for the habitual drug houses, and I think there's a lot of them where if anybody was paying attention and owned the property, they'd know what was going on and should have taken some action. Same thing with properties where prostitution goes on an ongoing basis. If somebody was paying attention, they'd know about it. It's to solve those sorts of problems. There are a couple of exceptions in it that you should be aware of. These types of ordinances have not been without controversy. Some of the ordinances that the triggering mechanism was just a certain number of 911 calls, 3 911 calls from a particular property in a particular period of time, came under some severe criticism, especially with respect to domestic relations issues, domestic violence issues, because there was a feeling that a victim of domestic violence would be chilled from making those types of calls because reporting the violence against the person might lead to their eviction or something on those properties. So this specifically exempts domestic violence from our statute so that that's not going to be an issue. And that's the way we've dealt with that. As a companion to this, we also have a proposal that would require the owners of rental properties to register those properties with the city. It would simply say that you would register a rental housing unit by its address with the name and mailing address of the owner, and if there's a manager of the property other than the owner, you'd give the name and mailing address of that person. This is just so that to enforce the chronic nuisance property, we have to be able to know what properties are rental properties and who they're owned by and or who are managing them. It's nothing more than that, but it's part and parcel of the overall scheme. That's my outline of it, but I'm sure you all probably have some questions about how it would work or may want to have some input into it.
Who has rental property here? What's your take on it?
Well, you know, I do have rental property, and I do think as much as I'm at my properties, I do not know all the time of what goes on, and I would just want to look things over to make sure that if 911 calls are being made to in regards to illegal activity or potential illegal activity, that we have some mechanism to alert the property owner.
I'm going to jump in here whenever you finish, and I'm going to.
So that the only time I find out about this is when I'm served a summons to court. You know,
well, it wouldn't work that way. That's sort of the beauty of this system.
Yeah.
How it would actually work. And just using you as an example, I'm sure it would never happen with any of your properties, but if something was,
I hope not.
well, yeah. But if something was going on that you didn't know about, what would happen was you'd get a letter from the chief who would say, we've had evidence that these activities were taking place on your property. Within 7 days, please contact me. You would contact him and come in, and you all would sit down, and you'd say, I didn't know what was going on. He'd tell you what was going on, and you would work out a plan.
I mean, as a responsible property owner, I love the idea because I know I would want to know if there was some issues that could possibly impact my property and the people that are living there, especially if I have some multi-units and I don't want others being disturbed by illegal activity as well, and neighbors.
The other protection to the property owner, I think, is if you assume somehow that that the chief and I were pushing something that we shouldn't have been pushing and do take it to court, then you've got this defense that we just talked about, which is basically it's a defense that says, I don't know, and I could not have reasonably known if I'd been doing what I was supposed to do about my property. So that's an absolute defense as well, which I think is important to provide protection to property owners who, again, might be trying to do the right thing, and yet, despite their best efforts, something happened that they didn't know about.
I'm going to jump in here for just a second. I do not own rental property, but I do own a company that manages rental property, and so I'm kind of looking at all of this through that. I have a couple of questions, and first let me say, I think you guys have done a great job in trying to get to a place where our property owners are protected as well as the citizens around those properties and the people who live there. So I'm not throwing stones. I
No,
just have a
that's-
lot of
that's-
questions. On this ordinance, and I'm gonna sort of go with Commissioner Perkins on this, and I know you said it's not calls to 911, that's not how ours is written.
No.
But on that list of nuisance activities, are those charges or are those convictions? How is that gonna work?
They wouldn't have to be charges or convictions, they'd be a determination by the police chief that this type of activity is taking place.
And it's his sole discretion, or are we putting some sort of committee in place that it's not? Because that's a lot to put on one person.
Well, it comes from the police chief first, obviously. He makes a determination. I've had 3 drug overdoses in this one particular property in the last month. That would, under this, would kick in the provisions, and he would then send a notice to the property owner that would basically say, I need to talk to you within 7 days. They come in and say, hey, you got drug activity going on in your house. I don't know if you knew it or not, but you do. And that's sort of where the creativity comes in. They would then, in essence, negotiate, how do we abate this? And again, it could be as simple as we evict the tenants.
Well, I
It
think
could be we put in a screening process.
It'll turn into a lot of evictions, and my concern is what happens to those people who are evicted from those? They just are gonna have to be, they'll be in somebody else's property. They'll be somebody else's problem at that point, and I'm not sure moving them down the line is the,
Well, I don't have any. I've got friends that have a lot of rental properties and all that, and their biggest problem is evicting anybody.
yeah, it takes ages.
Yes, it
I
does.
mean,
It's a
you go to
crazy
Californisburg
process.
and They may, I mean, you probably know, you don't handle stuff like that, but, you know, they may not do anything, you know. Of course, usually they take them for abuse of the property or they don't pay, basically. They just don't pay. They stay there. But even that deal, you don't need charges about anything. They're in your place, so if they don't pay and they signed a contract, which I think they do have to sign something for them, when they don't pay, they become a fraud to me, that they're living there free. But they go to Californisburg with it, and I mean, that's what I'm told. It lays a lot up there.
Takes a
Well, and
long,
again, the
long-
way it would work under this, and eviction's not the only remedy there would be, there'd be all kinds of them, but it's an easy one to use. If the property owner and the city had entered into a contract and said, this is what you're gonna do for abatement, and step number 1 is you're gonna evict the current tenant, and they agreed that, and they started eviction proceedings, that, it's not their fault if it gets delayed, and they wouldn't be in violation. I think our thing says that they would perform within 30 days or as long thereafter as necessary. So they start proceedings in 30 days. If it takes 3 months, if it takes 4 months, that's what it takes.
I do, and I agree with both the commissioners. We have to have something to protect the adjacent property owners that call me, and say, you just drive by and take a look next door, with the dilapidated condition, a couch on the front porch, or it's a washing machine's been in a side yard for 3 months, and, the owner, some of the owners aren't attentive, as long as they're getting their rent.
Yeah.
I mean, they're out there, come
Okay.
on, I mean, I'm not gonna name anybody, I don't really know them, but they're out there in our community, you see it when you drive around our town sometimes.
Well, another sort of creative thing that you could do under some of these agreements is a landlord could give the police department the authority to randomly inspect these properties. In other words, if you've got an agreement with your tenant that says that you can reasonably inspect the property, provided you give its reasonable daytime and place.
I feel like that's a massive overreach of the hand of government.
Well, we've got a problem,
Oh, I
and Chief can
realize
tell
that.
you.
I realize we have a
He could name
problem.
5 or 6 properties where, how many calls do you get in a month on same properties? With serious activities going on. Now, I mean, you all are the elected officials, we don't have to do this.
Well, I like this because you're not talking about code enforcement issues.
No,
The first sentence of this is chronic use of properties which foster criminal and drug activity and endanger the health, safety, and welfare of the Ashland community. Now, I remember this started because we had that neighborhood come out that had a rehab house in their neighborhood that moved in. And it was a different group of people that had never lived there before. They were kind of suspect of them and so forth. And I'm not against rehab houses, and they're legal. But, and so that's another story. But I remember when Chad came in here and did an interview with you, Mayor, and you mentioned something in the interview which really caught me. We have to sustain the integrity and the character of our neighborhoods. We owe it to our neighbors. And so I think it gives a lot of leeway. You're talking about 3 or more instances in 4 months, and then you go meet with the chief. I think that's pretty easy stuff.
Well,
Or
and not
6 or
to
more.
refer to a specific instance, but again, it wouldn't apply. I think somebody said, well, there's people in and out at all hours of the night. Well, that's not going to apply. That doesn't, that's not.
Right.
But they also are allegations, well, there's drug deals going down there on there every day. Okay, if that's true.
Right.
And if that was proven,
Right.
then this kind of ordinance can be used.
And I'm not
if
against these
people aren't doing
people.
anything
I'm
about it.
for these ones that pop up. But if he's getting constant calls that are taking officers to these places and they know, I think it's a good thing. I mean, and the transparency. There's a house up for me right now. There's probably 8 people living there. I don't know who the landlady is. I have no idea. And I'd like to know who she is. I think it's a good deal, and I applaud you guys for working on it.
Guess my only other comment would be, and to kind of answer to your point about the worry about a government overreach is, and if I heard you correctly, you're saying if the property owner agrees to the contract,
That was my next
So-
question.
you don't have to agree to anything.
Absolutely right.
You can fight it if you want in court or however you choose to, if that's where it ends up.
That's correct.
So this is an opportunity to remedy a situation without possibly going to court, but also making the property owner aware, in case they weren't aware, that they had an issue and we want to help them see a better outcome. And it still doesn't answer the point, which I'm also concerned with, is if there is an issue with somebody being there that's got a substance abuse issue, that we also, if it's not drug dealing, but it's drug abusing, that we look at social services opportunities for those folks as well.
You know, I'm always looking at, like I said, and I don't have,
domestic
I don't
violence
have an
or-
issue, we've got to do something, and I agree with that wholeheartedly. But I always lean to the, yes, we do this, but then what happens? What problems are we causing? It kind of in the domino effect.
I think
So that's
Mr.
where my
Perkins-
brain always goes.
Your analysis was right spot on, because first of all, the property owner doesn't have to agree to anything if he doesn't think he has a problem. And then what would happen was we'd make a determination whether to take it into circuit court or not, and then you'd be in a civil litigation situation just like in any other, and he would have the defenses that we talked about. I suspect, Commissioner Clark, that this would not be, I don't think the chief's gonna be using this 50 times a year, because it's, frankly,
No, and
it's a
I
little
don't
cumbersome.
think that he would, but like I said, my concern is, yes, it may be a nuisance property, and we get that person out of that nuisance property, well, now we have a newly homeless person.
Or we have a nuisance moved to another property.
And we're not gonna solve the drug problem or all criminal
They might move
enterprises
out of
by
town,
doing
too.
this.
Yeah.
But we are at least
might
identifying
move out of
certain
town.
properties that it's been congregated in, this problem. Doesn't solve everything, I
I
agree.
like the way that it's crafted, because it's a solution-based thing, not a strong arm thing. It's solution-based, and you go to the chief, you talk to the chief first before you ever, and then the person has to ignore the chief before he ever comes to you. I've got a friend in my church that has 118 properties in Huntington. And Huntington passed this, something similar like, he loves it because it gives him teeth in his process. And he tells the people, this is not going to be a nuisance property, you know.
Well, that was the concept, because some places just made it a misdemeanor and a fine, and you do this and bang, we charge you, and we are looking at a solution-based alternative here is what we're trying to
Like I
do.
said, I like the way that it's crafted. I just, like, I'm trying to get in my brain, are making sure we're not gonna cause another issue behind it. That's
Well,
just
it's
my
like
fear.
everything else, sometimes maybe you need to implement something to see how it's gonna work, and
Right.
I'm sure there'll be adjustments after a while. You can't give a shotgun approach to every issue like that, but we all agree, we've talked about it my whole term, I guess, of what are we gonna do about all this stuff. I think it's worth implementing.
I like this iteration of it better than anything we've seen.
Well, and listen, this is gonna, if it's adopted, this is your all's thing. So if you look at it and you see some things you'd like to talk about maybe changing, call me. I mean, it's,
I think the strongest point of it too is the engagement with the police department, because a lot of times you don't know what you don't know. And I think this opens a dialogue with the chief and his team, and I think it gives citizens the opportunity to get to know their police department better. And I think having that kind of line of communication open is helpful.
that's all I've got unless you all got any more questions.